Hello, everybody, and thank you very much for joining us for part 2 of our podcast with Robert Stephen, the registrar of the DIAC. If you haven't listened to part 1 yet, be sure to check that out, as it has some great background and insight into the Dubai Decree. In the second part, we'll now be jumping into some of the recent cases, including the case Narciso versus Nash. So let's jump right back into where we left off. Enjoy the episode. So I think if we move on to discuss some of the cases that had come up before the Narciso decision, there were 2 in particular that caused quite a bit of concern in the arbitration community here. One was the Baker Hughes case, which was before the Louisiana court, and the other was the DFL case, which was before the Singaporean High Court. In both of those cases, the court, whilst accepting the arbitration, in the Singaporean case at least, the court accepted the arbitration award in that question and permitted enforcement. However, in doing so, it said it was doing that on the basis that the party in that case had participated in the arbitration and had raised concerns, absent that participation, that the decree would not have been effective. And in the Louisiana decision, that was essentially whether or not anti-suit relief should be granted. And in that case, that the judge said that in his view, the decree could not force, in his view, parties to participate in DIAC arbitration when they had agreed to a DIFC-LCIA arbitration clause. Now, as we'll see, the DIFC Courts have disagreed with that quite fundamentally in the Narciso decision. But did either of these decisions cause any concern at DIAC or more generally, in your opinion?
No, it's funny that we're talking about these cases on this date. So it's the 6th of November for the audience's perspective, and it's just 1 week out from Dubai Arbitration Week. And I recall getting on stage to welcome everyone to Dubai Arbitration Week on the Monday evening last year, and getting a call from a journalist in London from a leading publication asking me to comment on the Louisiana judgment for press that evening. And of course, having just stepped on stage, it was not possible to do that. And then much of the next day and the day after that, being faced with questions in various different panels and various different sessions throughout the week. I think the answer that I gave then is probably the answer that I can give today, which is it wasn't that much of a surprise. I think it was bound to happen at some point in time, and I think any reasonable practitioner would have expected that. It had limited impact in the sense that it applies if you're interested in pursuing a dispute in Louisiana, but it doesn't have any material impact on the day-to-day operation of the centre and the vast majority of cases that are being pursued through the centre and under its rules. And that plays out in the statistics as well. The vast majority of parties that have chosen DIFC-LCIA arbitration agreements and DIAC arbitration agreements subsequent are doing business in and through this region, and are parties that are based in this region or have establishments in this region and looking to enforce in this region. And so from our perspective and my own private perspective at that point in time, perhaps not such a big surprise. It was going to happen at some point, but of limited impact, and really not a huge amount of thought was put into it thereafter.
I suppose the main concern I probably had when these decisions came out was that whilst the arbitrations can take place here in Dubai or in the DIFC, and the award can be issued, and as we've said, arbitral tribunals don't appear to have too much concern about the impact of the decree. When you're looking at enforcing that arbitration award at the end of the process, and if one of the opponents is in a jurisdiction such as Louisiana, there can be concerns about whether or not what you've spent many years fighting for and spent considerable money pursuing is then not enforceable in the jurisdiction you go to.
Absolutely. And look, as this institution internationalizes and as our caseload changes, and it has changed actually over the course of the last 3 or 4 years, and it has become more international over time. But if we go back in time, and if we have a look at the types of agreements that had a DIFC-LCIA arbitration clause in it, I think the proportion of those where international enforcement is likely is probably relatively small when you look at it in the totality. And so that's why I think from a private perspective and perhaps from an institutional perspective, it probably felt, well, yes, it's obviously going to impact some, and people will need to take an informed view as to whether it's worth pursuing or whether it's worth just doing the sensible thing, which is just, if you have a concern and parties are being reasonable with each other, agree to something else. And I think that goes. We'll probably come on to this, but I think this goes back to a point that was made, in the DIFC court case. Fundamentally, the parties have agreed to arbitration, and whilst the choice of institution is a material part of an arbitration agreement to an extent, at the end of the day, they've agreed to arbitrate their disputes, and it's hard to justify a party objecting to arbitration. And so if the institution has fallen away, the options are an ad hoc arbitration, or in the case that we're talking about, an LCIA arbitration, which is essentially the same as a DIFC-LCIA arbitration, or a DIAC arbitration. Do the right thing and be sensible and agree to one of those, because ultimately I think most tribunals will not look favourably on a respondent that pursues unreasonably, accepts that arbitration is the choice of the forum for the dispute, but objects to agreeing to a sensible place to have the dispute administered.
I entirely agree, and certainly in some of the cases that I've seen, you have pragmatic parties who, even midway through a dispute or in the early stages of the dispute, sit down and have these discussions and come up with something that they can sensibly agree. But invariably in arbitration as well, you have recalcitrant counterparties, often the likely debtor under the future arbitration award, who will take any and every point, and this has obviously been something that they've been able to, that type of defendant has been able to rely upon to try to string things out and cause some issues. There was one interesting point, I think, that came out of the Singaporean case, where they considered the press release that had been issued by the LCIA and DIAC jointly, which essentially, as you said earlier, set out the framework for who would deal with the cases up until a particular point, and then everything was then transferred over to DIAC from the LCIA from, I think it was February 2022, and they took everything forward from that point. Now, one of the points that came up in the Singaporean case was the fact that this hadn't been kind of formalized in a kind of formal agreement between DIAC and the LCIA. It was just kind of more of an informal press release. Do you see any scope for any more kind of formalizing of the kind of agreements reached between the institutions to give some more weight internationally to what has happened? Or do you think we have the decree, and now we will have the subsequent kind of implementation, objections in some courts perhaps, and as we'll see, a kind of affirmation of that decision in others?
It's not for me to confirm or to deny whether there is an agreement in place between the institutions, but I think it is a bit of a stretch for the Singaporean court to assume that it is just a press release. And I think you can read into the press release that there is an underlying agreement between the two institutions that sets a framework for the transition, and I think that is implied in the press release, if not expressly stated in it.
Certainly my reading of the press release. Unfortunately, it's just not.
It's not a. To the extent there is an agreement, it's obviously an agreement between those institutions, and it's not something that's in the public domain, because it would have been made public if that was something that had been agreed. But I think it's a bit of a stretch to assume that it's just a press release, and the press release provides the framework for the transfer of funds, for example. You're just looking at it from a practical perspective. The reality of what was agreed between the institutions and what is set out in the press release is that all of the existing DIFC-LCIA cases as at the date of the decree would be transferred to the LCA for direct administration by the LCA court in London. And as a result of that, the funds would be transferred to the LCA so that they could directly administer those cases in the ordinary course, and they've done an admirable job of doing that. If we look at their statistics for 2023, of 134 cases, I think they've now managed to close 100. I think there's 13 cases that are very close to being closed, and there's 18 cases left that are either stayed or being actively pursued by parties. And then, of course, the cases that should have been registered in that 6-month transition period, what happens to those? Well, it was agreed that those would be registered by the new DIAC, if we can call it that. And then, of course, the cases that come in after I think it was the 22nd of March, 2022.
And then moving on to what's kind of transpired this year, and against that background of some potentially unhelpful judgments overall. We had an interesting case that came before the Abu Dhabi First Instance Court and then the Abu Dhabi Court of Appeal, which was the Vaned Engineering against Reem Hospitals case. And there you had overall a very detailed, the first instance judgment, so it's a very detailed judgment which asserted that the decree was essentially effective. And that the arbitration clause in that question, which provided for DIFC-LCIA arbitration, was effective and should be enforced, and the Abu Dhabi courts declined jurisdiction. Now, the court in that case didn't get into the nitty-gritty about how the decree was to work. It simply said that the arbitration clause was still effective and that it would decline jurisdiction in that case, and that was upheld by the Abu Dhabi Court of Appeal. Was the centre aware of that decision, and did you have any thoughts about that? Obviously, sometimes it can take a little bit longer for decisions in the courts of the Emirates to come out, as they're not as easily publicly available.
We were aware of the judgment in the same way that the legal community was. We don't get advance notice of this sort of thing from any of the courts in the territory. As I mentioned earlier on, we're an independent, impartial and neutral arbitral institution, and so we find out at the same time as everyone else. And we read the judgment with interest, and I think as you've described, it was an extremely detailed and reasoned judgment.
And a cornerstone of the judgment was that the decree in many ways protects party autonomy as opposed to undermining it, and protects arbitration agreements. And there is a reference in that judgment to the Baker Hughes case and the criticism that the U.S. courts, the Louisiana court, had made of the decree and its impact upon the agreement of the parties. And I think in quite a well-reasoned manner discusses why actually what has been done preserves that. Because as you were saying, the choice is either, in circumstances where you've decided that you're going to abolish one of the institutions that administered an arbitration, the choice is either to put something in place that then is a fallback for the parties, or you just let the arbitration clause become invalid because there's no applicable institution, and it becomes a free-for-all, and you're fighting over which court you should be in, whether you should be having an ad hoc arbitration. So I think the reasoning behind it, that actually this isn't contravening the will of the parties, it's reinforcing the will of the parties by ensuring what they had agreed can continue following the abolition of something, is actually a positive thing. And I think the judgment was also quite important in that it noted that the parties aren't forced to choose DIAC. The parties can, if they want to, agree something entirely different. If they say, well, we really liked the DIFC-LCIA rules, then they can agree to apply the LCIA rules. Obviously, you'd probably say, please don't choose the DIAC rules. But overall, I thought it was a very positive judgment in the way it approached the questions.
Absolutely. It goes back to the fundamental point. The parties have agreed to arbitrate their disputes in the circumstances that you just outlined. The fallback position is that you have an institution that can administer the dispute if the parties are unable to agree, and if the parties want to agree an alternative that better reflects what they believe they agreed to at the time they entered into their contract, they can do that. But as we all know, arbitral institution rules and fees and charges change over time. You can enter into a contract today and the rules could change tomorrow. The fees could go up quite significantly tomorrow. That's it potentially is a different flavor of arbitration. Now, we're lucky that in our experience as arbitration practitioners, that most institutional rules are pretty progressive in terms of the changes that are made, and it's not too dramatic. But there's nothing to say that an institution can't just take its rule book and tear it up and start again and go for a completely different methodology and system, and you're bound by that unless you specifically agreed to apply a specific set of rules, which we all know is very rare, and most parties agree typically to the arbitration rules that are in force at that point in time when the dispute arises.
Yes, no, I think that's a very good point. I mean, I'm not sure I've ever seen in a contract someone specifically set out the specific edition of the arbitral rules that they're obviously it's technically possible.
I have, and it was a set of rules that were 1974 of particular bizarre institution in far-flung country, and being able to find those is particularly difficult. And I know anecdotally from having worked at another institution that the older the rules are, the more important it is to keep the hard copies of those, or to make sure that they're then scanned in and saved because they're not readily available.
Interesting. We've actually had that problem recently. We have a case that refers back to the EMAC rules, and I don't think they're actually available online anymore. So luckily we had an old hard copy of them knocking around in the office, and we were able to refer back to them. But I completely agree. So you had this, we think, quite positive decision from the Abu Dhabi courts on the issue, and then there was a case that we have acted on recently, the Narciso versus Nash case. It was an anti-suit injunction case. So I think the point that I was going to make first is that the decision of the court was approached through the kind of American cyanamid principles. None of the decisions of Mr. Justice Black in that case were final determinations of these issues. They're all on a kind of arguable case perspective, which one has to approach injunctive relief from. So this isn't a final decision by the DIFC courts on all of these points, but I think he was very clear about where he was coming from. And I'd be surprised if the DIFC court were to reach different conclusions if and when it has to decide these matters on a final basis. But Justice Black's approach primarily was that because the DIFC courts are a DIFC institution, the decree is a Dubai law which applies to both onshore Dubai and the DIFC, and therefore it has direct effect in the DIFC and has to be applied by the DIFC institutions, that the DIFC courts have to apply the decree, and as a result of that, they then therefore have to enforce an arbitration clause as the decree sets out, i.e. if the parties don't agree something else, that DIAC is to be the administering authority of the arbitral proceedings given the DIFC-LCIA has been abolished. So given that logical reasoning, it's a very strong decision to say that any DIFC-seated arbitration which provides for DIFC-LCIA arbitration, will be protected by the DIFC courts, and they will enforce that arbitration clause and enforce DIAC arbitration for those proceedings. So the ratio of the decision is generally very, very helpful, because a large chunk of the DIFC-LCIA arbitration clauses will either, by reason of the choice of the parties or by default under the old DIFC-LCIA rules, have the DIFC as the seat of the arbitration. So overall, the kind of main ratio of the case is a real affirmation of the decree and the effect of the decree.
I think that's right, and just going back to statistics, I think at the time of the decree, looking at the DIFC-LCA caseload, I think the parties' choice of seats was broadly 50-50 split between Dubai and DIFC, and so broadly speaking, 50% of all the agreements entered into between parties would have had a DIFC seat, and that's largely reflective of what we're seeing today in terms of the current caseload as well.
Yeah. That's it. But now under the current rules, the DIFC is the
default seat, of course,
isn't it? Well, it's under the previous rules, onshore Dubai would have been the default seat. So overall, the main part of the decision is, I think, very helpful for arbitration practitioners and gives us a degree of certainty that probably wasn't there before. But the more general discussion in the judgment, I think, is quite helpful, because it leans very heavily on the Abu Dhabi case that we've just been discussing, and does consider the Baker Hughes judgment. And Justice Black comes down very heavily on the side of how the Abu Dhabi courts had approached this, and saw the matter as the government trying to ensure and protect the arbitration agreement of the parties and the choice of the parties in light of the abolition of the DIFC-LCIA. And he essentially adopts wholesale the reasoning that the Abu Dhabi courts took on this issue. So again, I think a very positive general piece of judicial thinking that, whilst obviously applicable to the DIFC, hopefully will be something that will also catch the attention of other international courts to say, well, we don't just have to take the approach that maybe in Singapore has been hinted at and in Baker Hughes has been hinted at. There is actually good judicial reasoning to say actually what's taken place should be recognised, and we should enforce these arbitral awards in different jurisdictions.
I think that's right. I think, and we can be hopeful of that. And I'd like to think that the occurrence of this will get less and less over time as more and more parties feel comfortable to either revisit those legacy DIFC-LCA arbitration agreements that they have and to choose Dubai International Arbitration Centre as their institution of choice, or ultimately those contracts have no disputes that flow from them, and they just expire.
And as you mentioned, it's arbitration week next week in Dubai. I think actually as the podcast drops, it will be arbitration week. So I was hoping we could just finish with you letting us know a little bit about what DIAC has planned for arbitration week, and then looking more into the future, what the institution's got planned in the near term for its development as the leading institutional arbitration in the Middle East.
Well, we're very much looking forward to Dubai Arbitration Week. I think we have 142 events this year in the calendar, with well over 1,000 people signed up for the opening reception. It's set to be a very, very busy week. At DIAC, we are hosting a joint event with Hong Kong International Arbitration Centre on Tuesday, the 12th of November in the afternoon. And that will very much have a technology focus. So how is technology impacting the practice of international arbitration? What is happening today? What is happening tomorrow? And how are we all adapting to that? We've got a fantastic panel of leading tech providers who are coming in to set the scene and to let everyone know what is currently being used and what is in the pipeline. And then we've got a panel of lawyers, in-house counsel, arbitrators, and they're going to discuss how technology is impacting their practice today and what they consider to be the do's and the don'ts of adopting it. And I think technology probably is our future. If we segue into that, I think we as an institution want to be forward thinking and forward looking, and want to be front and center of the shaping of the future of arbitration practice and procedure. I think what we will be doing is making announcements in the not too distant future about significant tech investments for the institution to assist it to be more effective in its case administration, to help parties and perhaps provide them with some additional services, and to assist tribunals in the rendering of the rewards. So I think there's a very important piece there. I think the institution is looking at lots of additional services that it can provide to parties, from physical hearing facilities to virtual hearings, and associated services to fund holding. There's lots of things that are on the table for the institution, and it's a particularly exciting time. And I think also just internationalizing the centre, we are very much focused on being a leading international arbitration centre, not a centre for the United Arab Emirates, not a centre for the region. We recognise that has been the centre's bread and butter for the last 30 years, and we very much want to continue to serve those parties that have been using the centre and continue to use the centre. But we are very much looking to internationalise the institution and to service parties that are doing business in and through the region and that are looking for an alternative to some of the more established institutions, particularly those parties that are based in China, India, and in other parts of the world. So we'll be very much focused on that, and I think that is our future focus.
No, it sounds very exciting. I think it's definitely the way that Dubai and the UAE itself is moving. It's certainly kind of, from what I've seen in terms of cases and clients we've been working for, Dubai and the UAE continues just to grow as an international hub, and you're having a lot more businesses setting up a presence here or actually moving their entire kind of center of gravity here, given its just strategic position between the East and the West. So I think in terms of timing the growth of the center, it probably marries up very well in terms of where the UAE itself is moving as a country.
Yeah, we just need to look out the windows. Busy. There's cars on the roads. There's people walking around. There's business to be done. And whilst people may criticise that during Dubai Arbitration Week as they go from event to event, I think it's a good sign. It's a good sign for the city and business that's being done, and it's a good sign for the future.
Right, well, thank you very much for joining us to discuss these developments over the last couple of years. I know you've had to discuss them many times before, so thank you very much for taking the time. I hope our Arbitration Week goes well, and thank you everybody who's been listening.
Thanks very much.